We will go on the record in the matter 24 CM 196, State of Wisconsin versus Scott Lang.
In 1991, 24-year-old Scott Lang ends Pine County Deputy Michael Morrow by beating him with Morrow's own flashlight during a traffic stop. In 1993, Lang is sentenced to 20 years in prison for second-degree ending of a life. That same year, while in prison, Lang is convicted of trying to smuggle prohibited substances into prison and is given an extra year and 1 day on this charge. He serves 15 years and is released on quote-unquote intensive supervision in 2006. After his 2006 release, Scott Lang breaks the terms of his parole and is sent back to prison. After his second release, Lang is arrested again in November of 2008 for, quote, violently assaulting his juvenile daughter after she damaged the family car by closing the garage door on it, end quote. Lang pleads guilty to third-degree assault and is sentenced to 15 more months in prison. He also receives an additional 24 months in prison for violating probation and multiple domestic assault violations. Lang is released in March of 2012. Then in August of 2013, he is charged with domestic assault and interference with a 911 call and is convicted of damage to property and disorderly conduct. In 2014, Lang is convicted of misdemeanor assault and obstructing the legal process and disorderly conduct. In 2016, he is again convicted of disorderly conduct. In September of 2017, 51-year-old Scott Lang is charged with, quote, 16 felony counts of violating a no-contact order within 10 years of the first of 2 or more convictions, end quote. At a November 2017 plea hearing, Scott Lang pleads guilty to, quote-unquote, a variety of offenses committed in 2016 and 2017 and is sentenced to 72 months in prison. That's 6 years, so he should have been released in 2023, but I could not find any reports confirming that date. Which brings us to June of 2025. Scott Lang is once again footloose and fancy-free and is once again in trouble with the law. He is accused of violating a harassment injunction against his neighbor. Lang is accused of throwing fireworks at the woman's car and house and I think trespass while under a no harassment court order. And once again, Lang is offered a plea deal. The twist in this case is that Scott Lang confirms all our concerns about plea deals in the justice system. Judge Mogen allows Lang to speak, and his conduct and words leave no doubt that there's something very rotten in Denmark, especially at the end, when the judge has to go back on the record. Hard to believe that just happened.
The appearances are Mr. Lang appears in person with his counsel, Christopher Gramstrup, in person. We have the state appearing through District Attorney Kevin Schmidt. We're set today in this matter for a plea and sentencing. And that is proceeding as such, correct, Mr. Gramstrup?
Yes, Your Honor.
And I do have a plea questionnaire waiver of rights form in front of me. Mr. Lang, do you recognize this document?
Yes.
And did you sign this document? Yes. Mr. Gramstrup, can you please recite the agreement for the record?
Your Honor, Mr. Lang would be pleading guilty to count 1. Count 2 would be dismissed outright. There's a joint recommendation on count 1 for a 1-year probation, 4 months county jail as a condition imposed and stayed. No sentence credit due.
Mr. Lang, you indicated that your attorney went over this document with you, go over it thoroughly.
Yes.
Did he essentially go over it word for word?
Yes.
And do you understand everything on this document?
Yes.
It states that you're going to plead guilty to 1 count of violation of an injunction restraining order. You're 59 years old, you have 10 years of schooling, you can read, write, and you understand the English language. Is that correct?
Correct.
You're not receiving treatment for mental illness or disorder, no alcohol, drugs, or medication.
No.
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
You also understand that there is a recommendation, a joint global offer that you've reached, where there would be a recommendation to the court for 1 year of probation with an imposed and stayed sentence of 4 months in jail. Do you understand what that means?
Yes.
Do you understand that I'm not bound to follow that recommendation?
Correct.
If I thought based upon the facts that it was more aggravated or that you deserved or should get a harsher punishment, do you understand I could sentence you to the maximum penalty?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Mr. Gramstrup, did you thoroughly go over the facts that are alleged in the criminal complaint with Mr. Lang?
I have, Your Honor.
And do you believe he understands those facts and what the state would need to prove the elements of the charge?
I'm quite confident that he does.
May the court use the probable cause section of the criminal complaint to find a factual basis?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
As to count 1, violating a harassment restraining order injunction, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed outright. A judgment of conviction will be entered today. We do have victim who is present here. Does victim wish to make a statement? All right. The victim can come up to this black little desk and you can either state your name or your initials, whatever you feel the most comfortable, and provide your statement.
I write this with the burden not only of my own experience, but out of the accumulated fear, anxiety, and harm carried by others who've had the misfortune of encountering Scott Arlen Lane. What I detail here is not theoretical. It's a chilling and relentless pattern that stretches across nearly 4 decades. I ask the court not to consider this man in isolation, but in the context of his life's choices, a legacy of violence, threats, manipulation, and a brazen disregard for the law. Let me begin with this. Scott Lane is not rehabilitated. He is not misunderstood. He is dangerous. His criminal history isn't abstract. It's a 23-page document that I have with me today of convictions of court filings that include, but are not limited to, second-degree murder, felony strangulation, felony domestic violence, assault on a peace officer, possession, fleeing police, multiple counts of violating no contact orders, criminal damage to property, harassment, and disorderly conduct. Repeatedly. In almost every instance, the response was probation or supervision, which he's violated more than a dozen times. Statistically, the risk associated with this level of criminal history is staggering. A study by the U.S. Sentencing Commission found that individuals with more than 7 prior convictions have a 61% likelihood of reoffending. Scott Lane's record exceeds that threshold by a wide margin. He is not a former offender. He is a persistent, ongoing one. The violation in front of the courts today was not a one-time incident, but rather just one more chapter in Scott's long, escalating pattern of violence. A previous prosecutor had stated on Scott's past charges, they reflected ongoing themes of violence, confrontation, and paranoia. On April 12th of 2018, the state on record stated that they recognized these as persistent patterns, and they are still present today. On June 26, 2025, in yet another courtroom, in yet another criminal case involving violence and confrontation. While previously incarcerated, Scott had been removed from a jail treatment program for physically assaulting another inmate, further demonstrating his inability to manage aggression, even in a controlled environment. He has repeatedly told others he is a target on his back and that the was in the past, as if that absolves him. But when angry, his instinct is to weaponize his past, and he said to me directly, "Do you know who I am? Do you know what I did?" A chilling reminder that he uses his violent history as a tool of intimidation. Scott is on body cam stating, "I am starting a plan. I ain't playing this game with her. She's going to be dealt with. I have connections. Her, she is the most worthless I've ever known. Let her know I'm done, and I'm going to make plans if she doesn't get out of my life. I'm getting out of here because I don't want anything bad to happen, because I know what's going on in my brain. I'm going to study the house, and I'm going to make some inquiries. You think 30 years in prison, being with PBMs, Hell's Angels, I don't know, connections? She should be smart and move here. Scott has bragged about Deputy Michael Moreau, not only to me, but in other criminal cases where he threatened a Menards employee, stating he had a cop and that people should be careful around him. These are not the words of someone seeking redemption. They are the boasts of someone who sees past crimes as leverage. While these cases may not be the direct subject of today's hearing, they remain highly relevant to his behavior and his mindset, which continue to demonstrate he is unrehabilitated and is incapable of becoming a productive member of society. Scott is admitted to drinking and using substances. Scott has used alleged substance abuse to justify previous convictions. His paranoia is well documented in decades of police reports and court transcripts. He will frequently claim people are out to get him or that he's being targeted. He's, again, even claimed to have connections to people, a statement that should raise immediate concern for anybody who is tasked with protecting the public safety, anyone who represents the courts that's sitting in this courtroom today. Violating probation is not just a minor slip. According to research published in Criminal Justice and Behavior, each infraction during probation increases the chance of reoffending by 700%. Scott's repeated violations, including substance abuse, no contact violations, and threats, they are not technicalities, they are predictors of future behavior. In a Minnesota court transcript, a jail call is referenced in which Scott contacted the very wife he claims to love who's sitting in this courtroom today. Immediately after Danko was dismissed, Scott asked Roxy to put her son on the phone and said, apparently there's some problems at home. He insinuated his stepson would be assaulted, implying retaliation or violence was imminent upon his release. He called Roxy again on another number, referring to her son as the spawn of Satan, and continued to berate her. All of my problems started when I met you. You're so messed up you could ruin a dream. This is not love. This is coercion, manipulation, and control. Again, consistent themes in Scott's behavior. If Scott is willing to treat the people he loves this way and states on body cam, I might only have 6 months or a year. I'm trying to make as much money for my wife. I'm trying to set up my wife the best I can. What is he capable of doing to someone who he has no feelings or relationship for? Someone he does not love or care about? In 2024, in this very courtroom, in front of you, Your Honor, I was issued a 4-year injunction against Scott and Roxy Lane. During this time, Scott had retaliated by making false allegations and filing a false restraining order against me. Scott was aware of the restrictions this injunction ordered. However, despite that injunction clearly prohibiting contact, he committed 2 new violations on July 8th and September 26th, resulting in why we are here today. On July 8th, he fired explosives, also known as fireworks, at my home and vehicle, striking my home and my car. When it hit my home, it was loud enough for my children and I that we thought bullets had came through our home. My children were terrified. Scott had admitted to being intoxicated and told officers he was done playing and had connections and was going to go out with a bang. He said he was starting to plan and that I, Marissa, was going to be dealt with. These are not idle threats. They're the words of a man who's already strangled his wife and physically abused not only his daughter, but his stepchild. On September 26th, he and Roxy Lane drove into a restricted area in direct violation of the injunction. Both parties were subject to active court orders. I again provided video evidence to law enforcement. This was not a misunderstanding. It was a calculated act of intimidation. What Scott and Roxy fail to realize is that my home is equipped with a professionally monitored surveillance system. A security company provides 24/7 active monitoring, always recording and reviewing footage. Even when I'm not home, I have full remote access that I can monitor every angle of my property, the front, the back, the sides of the house, the garage, the parking lot, across the street, and even the surrounding fields. In addition, there's multiple trail cameras throughout the fields for added coverage. There is no uncertainty that Scott was caught. The footage is clear. This is not a matter of opinion or debate. He may have attempted to claim it was his brother Gary, but that argument does not hold, as our family has known both individuals. We know what Gary looks like. We've seen him at Scott's residence. Furthermore, Gary has a criminal record with an official mugshot, making it unmistakably clear that they are not the same. Attempting to confuse or deflect responsibility in this way is just another manipulation tactic, and one that fails in the face of documented evidence. Even with my restraining orders in place, Scott has continued to stalk me. He's entered my driveway, harassed family and friends, used his wife to deliver a 20-page handwritten letter defending his actions and accusing me and my church of worshiping the devil in the basement. This is just not harassment. It is now psychological warfare. Law enforcement has been called to Scott's residence other times within the past year for incidents involving domestics and violence towards others that I've witnessed Burnett County Sheriff's Department at his home for calls that I did not initiate. On several occasions, Roxy had also reached out to me in fear, admitting that Scott was back on methamphetamine, asking for help to get him out of the house. She had specifically requested resources from me, knowing I was working in the capacity of a legal advocate in the court system, further underscoring the seriousness of her situation and the danger she felt. Scott had moved to this town with the intention of hiding his past, but when someone, not me, uncovered it and the community began to learn the truth, he spiraled. Instead of seeking redemption, he chose retaliation. Scott alleges we were friends until I heard 35 years ago he caught. What Scott fails to mention is, I discussed this at great length with Scott and Roxy, and I informed him I in no way supported his past choices. However, I can recognize he served his time and had not harmed myself or my children. He also fails to mention he and his wife had brought us over a handmade cake, snacks, and a handmade holiday card after this exchange, as we had put this behind us in an attempt to move forward. Many people ask why this betrayal cuts especially deep for me. It's because I've spent my career working in reentry services, helping formerly incarcerated individuals reintegrate into society with dignity and respect. I've also worked on the other end of victim advocacy, helping survivors find their voice. I firmly believe in second chances, and I firmly believe in rehabilitation. Had Scott shown a shred of respect for me, my family, or this community, I would have been probably among the few willing people to stand behind him and offer him that chance to prove redemption. But he didn't. He weaponized my compassion. He used proximity and legal loopholes to terrorize me. Multiple other district attorneys' offices, time and time again, have failed to protect the many victims who have suffered under Scott's ongoing reign of violence. Even today, the proposed plea deal of 1-year probation is not just inadequate, it's dangerous. It sends a message that victims don't matter. Threats don't matter, and the system will always bend for convenience. It sends another loud and clear message to Scott that he got away with it again. While this case isn't resolved today, Scott faces new criminal charges also in Kanabec County. He was charged with 3 counts of disorderly conduct, including brawling or fighting from an incident on August 15th of 2024. That jury trial is scheduled for August 18th this year. This is not a man learning from his mistakes. This is a man who continues to reoffend even while under court supervision and on bail. He is not just a repeat offender, as I stated, he is a current offender. The danger he poses again is not theoretical. It is real, active, and continues to escalate. According to the Bureau of Justice of Statistics, over 70% of state prisoners are rearrested within 5 years, and violent offenders are rearrested at even higher rates. When you factor in repeat domestic violence, strangulation, criminal threats, those odds continue to rise dramatically of reoffending. This court must recognize that probation in Lane's case is not a rehabilitative opportunity anymore. It is a revolving door that places victims and the communities that we all directly live in harm's way. Under Wisconsin Statutes Chapter 973, this court has the authority to depart upward from any sentencing recommendation when aggravating factors are present. Scott Lang is a habitual offender and has shown no remorse, no accountability, and no willingness to change. He's a danger to me, to my family, and to every member in this community. Probation is not justice. It is not safety. It is not accountability. If this plea is accepted, what message are we sending to victims? Is our safety negotiable? That the hours we've spent filing restraining orders, calling in the police, appearing in the court, collecting evidence, and reliving trauma in front of strangers, does that mean nothing? That abusers who stalk, assault, and terrorize can walk free with just a signature and a promise to behave for another year? That this abuse is negotiable, that even the most credible threats and repeated violations are nothing less than paperwork? That's not justice. It's traumatization by the process. Every time the system chooses expedience over accountability, it erodes public trust and inflicts fresh wounds on those who have already suffered. We're not just reliving our trauma, we're forced to participate in a system that looks the other way while it happens again and again and again. You're telling those who have endured physical and emotional abuse, those who've had fireworks launched at their homes, who've been stalked, threatened, silenced, those who have been murdered, that their fear is less than important than court efficiency. You're telling future victims to brace themselves, not just for the violence, but for the system's dismissal of the violence. If this plea is accepted, everyone with the authority to act and hold Scott accountable becomes complicit, not just in failing to act, but in granting permission for the harm to continue. But you, Your Honor, you're not bound by that failure. You have the authority to reject this plea and impose a sentence that reflects the gravity of Scott's ongoing actions and ongoing threat he poses. I urge you to consider the full weight of his history, his choices, and the lives he's impacted. This is not just about punishment, it's about prevention. It is about sending a message that the victims matter and that their voices matter and that my voice matters, and that the system will not tolerate those who continue to seek to harm others, manipulate, intimidate, and break the law. I would ask that Scott be remanded for the full 9 months, if not longer, and taken into custody today, as well as a DANCO or no contact order be updated to include my minor children, as they were listed in the criminal complaint and do not have protective orders currently in place. Thank you for your time and consideration.
Thank you.
Thank you.
All right, Mr. Lang, that was not appropriate. Is this funny?
No,
Don't do it, Scott.
no, it's not.
All right, Mr. Schmidt, argument from the state, please.
A duty of candor before the tribunal, reviewing his criminal history. The victim related that she believed that he has criminal convictions for harassment and strangulation. I do not see those. I know nothing about the actual facts she states of his past criminal convictions. And the court obviously can't consider any pending case in Minnesota for, I think she said, disorderly conduct. So we know how we do sentencing here. The court must first consider probation unless it unduly depreciate the seriousness of the offense. This is not a violent crime. This is not a murder. This is not a domestic violence offense. The victim got a restraining order against her neighbor, and her neighbor fired fireworks towards her property. This would be probably a fine case if not for the fact that, as the victim said, Mr. Lang does have a criminal history. That is how this is aggravated to require probation with the 4 months state and imposed jail, given what the violation was, firing fireworks towards his neighbor's property. I understand that this is intensely personal for the victim. It's very clear that in addition to her feelings and her experiences with Mr. Lang, she's actually gone the extra mile to really dig in and research everything she can about Mr. Lang. But that's not really what the restraining order cases are about. Restraining orders come about, harassment restraining orders come about when relationships deteriorate to the point where people can't get on anymore. So they go to a court, and if they meet certain criteria, the court does an order that says you can't do certain conduct. The goal is to cause both individuals to live peacefully in the community with no further issues. we have a criminal offense for when people violate that in Wisconsin. That criminal offense is not organized in the public safety section or security against bodily harm section. It's located in the same section as contempt of court, because that is what the primary interest is of the restraining order. Someone has violated an order of the court. That is where the criminal penalties derive from. That is what it's structured after. That's why in this case, doing this probation to make sure things don't go on, having conditions of probation to not have contact with the children as well, so there can be no wedging, and to have some sort of absolute sobriety in this case. Mr. Lang did say that he was buzzed, and I think that was probably a connection to why he made the decision with the fireworks in this case, would be appropriate and would protect the public. It would give the victim a means to have a faster means of reporting future violations in the future. And it's the appropriate way to structure what the violation is. We don't go from complaint to injunction to 9 months jail. We go from complaint to injunction to some other penalty, and we have to ratchet up penalties. We don't do them. We don't punish individuals. We punish crimes. Mr. Lang does have an extensive criminal history. It is very serious and it's very violent. The last criminal conviction he has would have been in 2017, meaning he's already beaten those statistics about recidivism within 5 years. And that's another reason why we should believe that probation would be successful. I'd ask the court to follow the agreement and remember that this is a violation of a restraining order where someone fired fireworks at their neighbor's property in the context of escalating personal relationships with them. There's no domestic history between these two people. There's no past violence between them. That is what this case is. Thank you.
Thank you. Mr. Gramstra?
Thank you, Your Honor. First, I would indicate that I agree with everything that the state just indicated. First of all, this is a misdemeanor. It's a Class A misdemeanor. Mr. Lang is 59 years old. He's married to Roxy. They've been married for 9 years, despite what some of the court, what the court heard today. My understanding and my observations is they have a loving and caring relationship.
How loving and caring a relationship, you might be wondering. Quoting from a 2017 news report, a Brook Park man convicted in 1992 of Pine County deputy sheriff is facing new felony charges after authorities were called to his home to investigate a domestic assault incident. Scott Arlen Lang, 51, was charged before Judge P. Hunter Anderson with felonies domestic assault and domestic assault by strangulation and gross misdemeanors, 5th-degree assault within 3 years of previous conviction and 5th-degree drug possession. A domestic assault call was reported from the Lang residence. The victim reported Lang had struck her and was now barricaded in the house. The victim confirmed the visible bruise scar was from the morning assault, and during the assault, Lang took both of his hands and choked her, stating, "I could you at any second," then continued choking her while making other comments to her. There were scratch marks on both sides of the victim's neck. Bowker, that's the scene investigator, took several photos of the victim's face, left eye, her neck and throat areas, as well as her left leg, all of which had visible bruising.
She's an RN, she's a professional. I see no problems in their marriage at this point. He's got 2 daughters. He does have a record, as the state indicated, his last conviction was in 2017. He works side jobs as a mechanic type work on cars. He does have a heart issue that he's being treated for. Got no mental issues. He had a heart attack a few years back, and they're treating him for a heart valve issue. He likes to spend his free time working on cars, particularly classic cars, and bird watching. Does a lot of bird watching. I would indicate to the court, and the court's very familiar with me. I do not attack victims. Victims, I believe very strongly, have the right to say whatever they want to say at sentencing or at any other point. But I'll leave it at this. I do disagree with factually a lot of the things that were stated as facts by the victim. I know, as the state indicated, that not everything was entirely accurate. This case, from my perspective, Your Honor, was a very triable case. And having count 2 dismissed outright was important in the resolution of this. I know what the victim indicated about the video. I've seen the video, and I would be very confident in taking this case to trial. I put cases, basically, when I take a new case, Your Honor, I put them basically in my mind in 3 categories. The first is this case is not likely to ever go to trial. Then there's sort of a median where it could, it might not. And then there are cases where I think initially this is a case that's probably going to get tried. And after my first conversation with Mr. Lang, that's where this case was. I thought it was very likely headed to trial, but he wanted to accept responsibility here. He, again, especially as it relates to count 2, there would have been in my opinion, very credible testimony that that was not him driving the vehicle. And not just from the person that was in fact driving the vehicle, but from other people as well. And I've seen the video. His brother and he do look very much alike. I think it was very triable on count 1 as well. Now, no case is perfect. There are things on the other side that Mr. Lang and I talked about, and ultimately he said, I don't want to put the county through this. I don't want to put witnesses through this. I just want to get this behind me. His words were, I want to leave her in peace, and I want her to leave me to live in peace. That is his impetus for pleading today and moving forward. Since the injunction was filed in 23 CV 102, there have been dozens of calls to law enforcement about Mr. Lang, many of them completely unfounded. Whenever there's a dog running loose in the neighborhood, they show up at his door and accuse him of his dogs running loose when they're not. There was an incident where the police were called on report of a domestic because they heard him cursing and swearing. He was cursing and swearing. He was working on a car and was having difficulty, and he was losing his temper at the car and cursing and swearing. He was out in the open doing that. His wife wasn't even home at the time. So there have been dozens of calls that have not resulted, because they're unfounded, in accusing Mr. Lang of doing things that he just hasn't been doing. Again, he wants to leave her in peace. He wants her to leave him in peace. He wants this behind him, and that's why he's entered a plea today. He's accepting responsibility. He just wants to move on. I believe that the agreement that we have before the court is entirely reasonable. 1-year probation on a case, in my opinion, again, that was very triable, with 4 years hanging over him. It's got some teeth to it. So I would ask the court to approve that agreement. I think it's entirely fair and reasonable and meets all ends of justice.
Thank you. Just to correct you, it's 4 months.
I'm sorry, what I said 4 years. I'm sorry, I misspoke.
I know. I just wanted the record to be clear.
Yes, thank you.
All right. Mr. Lang, I'm now going to turn to you, and I'm going to ask you if you wish to provide a statement to the court. You do not have to, but it's your only time to let me know anything that you believe that wasn't stated correctly, or that wasn't stated at all, or anything about this matter and about you that you believe I should know.
Well, Your Honor, I wasn't going to say anything, but everybody in this court can see there's kind of a morbid obsession kind of thing going on here. And as my attorney said, we're trying to move on. I mean, there's so many lies made, about my past. It's crazy. We're even trying to move out of state, but with this morbid obsession, it's keeping us here in this state. We just want it done and gone. That's about it.
Okay. Thank you, Mr. Lang. When a court sentences an individual, I'm not sure where your 2017 conviction was. I don't believe it was here.
No.
It
was in Minnesota. It was in Minnesota.
Okay. At least in Wisconsin, when a judge sentences an individual, I have to look at 3 big factors and things. 1, the nature and the gravity of the offense. The second, I have to look at the defendant, your past criminal history, other things such as your age, your education, any needs for rehabilitation and services. And the third, I have to look at needing to protect the public. And although I can look at the public as a whole here, and I'm going to say simply because of your criminal history as a whole, but in particular, what I need to look at for protecting the public is MR. I forget her MR. And so that's where we look at with the public interest. Mr. Schmidt said it clearly that I am required to, by my higher courts, look at probation first. I have to look at probation unless I need to have you, or the community, the public needs to have you incarcerated to stop you from committing crimes and additional crimes. The second reason would be if cannot look at probation is if you need some type of treatment or rehabilitation that can only be met in an institution, in a prison, or in custody. The third thing is I wouldn't be able to put you on probation unless I must look at probation first, unless the crime unduly depreciates. Like if it unduly depreciates the crime, putting you on probation. And so I am directed from my higher courts that is the first thing that I must look at is probation and all of those other things unless something else falls into it. I understand, and I heard the victim's statement. It was very thorough, it was very thought out, it was very impactful. As I believe both attorneys have said, there are multiple things within that statement I cannot even take into account in my decision. If I do, overturned. There are multiple things in there I cannot use in deciding sentencing. Otherwise, I'm setting the court up for an appeal and to be reversed. I don't like that. And so I did take the heart of what MR stated, and in my knowledge, and I'm taking judicial notice of the 23 CV 102, that is the harassment injunction between you two. And so I do know some of the history between you two. You're both neighbors, both very close to each other with proximity. And that I believe at one time you were friendly, but then it turned. As both attorneys have stated, that with a case such as this, a harassment injunction violation, unless the behavior is so severe and so disturbing or violent, I have to look at probation first, because when I have to look at the incident and what happened, and here we're talking about fireworks being shot at the neighbor. Whether or not there are other incidents or other things that were captured on a camera, I don't know. I don't have that in front of me. The only way that I could have things like that in front of me is to come through the attorneys or to have them play it so I can visually see it myself. So all the facts that I have to go on are this one incident of the fireworks. So when you look at a case like this and you look at this matter and the violation of a harassment injunction, the underlying action here was not as serious as it could have been. But I do understand, I understand both of you right now. And I really hope, Mr. Lang, that you are meaningful and truthful in the fact that you say, I want her and her family to live in peace, and I want to live in peace. If I had the ability to build a wall that would separate both of your residences, I would do that. I would say a wall be built. You can't look in, you can't look out, you can't throw things over, you can't shoot fireworks, you can't do any of that. I can't do that. It's unfortunate that you both live in this same vicinity, and that it's not fair for either of you to have to move out Otherwise, one of you would have by now if you weren't happy with where you live, your actual residence. So because of the facts of this case, I must look at probation first, because the facts of this case do not unduly depreciate the seriousness of the offense. But I do have to take the victim impact statement into account in my sentencing as much as the law will allow, and as much as I'm allowed to actually use with regards to the information that was provided. Because although I heard much about your criminal history from the victim, the law says I must follow the criminal history that's provided to me from the attorneys. I understand injunctions extremely well. Not only did I practice law with that area as an attorney, but I see injunctions and restraining orders all the time. They are very emotionally distressful. They cause turmoil. And sometimes it's just with one individual, sometimes it's with both. And they have a significant impact on a person. And as MR indicated, she wants to live in peace. And again, I'm hoping that that is something that you're going to be able to do. So in needing to protect the public, I have to craft a sentence to try and ensure that there's not going to be any violation, and that the community, MR, and our family are protected. And so that is what I'm focusing on. And it will include, any decision and sentence here will include a no contact with victim, residents, and any family member that is there, and no contact through any third party, and that includes your wife. Rehabilitation is what the court is supposed to look at, and I can't, based upon the facts and what I've heard here today, I don't know if you've been rehabilitated from your past crimes. I don't know what you have done or what you haven't done. I don't know what your 2017 conviction in Minnesota was for. All I can do is sentence according to what I'm supposed to look at and how I'm supposed to protect in the ways that I can. With regards to the matter, probation is appropriate. But due to some of the things that I have said, and due to your criminal history, as Mr. Schmidt did state, that in this type of case, it is aggravated due to your criminal record. And it's unfortunate that I don't know any steps in rehabilitation or where you are. All I know is the facts that are in front of this court. So I'm going to give you an opportunity to show the world, to show MR, and to show yourself and your wife that you have the ability to live in peace and let your neighbors live in peace. But if you don't let them live in peace, and there are violations of your probation, violations of the restraining order, then you will be revoked off of probation, and your probation will be terminated, and you will be sent to jail to sit a sentence. And in a case like this, and in looking at all the facts, I'm going to give you the carrot of knowing that it's an imposed and stayed sentence, and have that hanging over your head of how important this is and how you must continue to abide by the parameters of the injunction. So what I'm going to do is I'm going to sentence you to 9 months of jail imposed and stayed. If you do all that you need to do, you stay in the straight and narrow, you don't need to worry about that. But if there's a violation, then you know that you will be revoked and you will sit 9 months of incarceration. That's a big incentive to live in peace. On probation, there will be absolute sobriety, no alcohol, no illegal drugs or substances. If you have a violation of sobriety, of absolute sobriety, you will sit 30 days of jail per violation. No good time, no Huber. That will be additional conditional jail in the violation, and you will go sit that in jail for each violation of absolute sobriety. And I'm going to warn you, with a violation of the restraining order injunction, if that occurs, because of the case and where it is and the facts of this case and what the charges are, most likely you're going to be revoked. Mr. Gramstrup.
He just asked me a question, Your Honor. It's something I can take care of later.
So it's very important that you toe the line. Hopefully, you said that you're looking at trying to move out of state. Hopefully, you're going to be able to do that and build a better life for yourself and for your wife. And then hopefully this can end. I'm going to tell you, one of the some of the worst cases that happen involve neighbors and neighbors disputes. And it can be extremely dangerous and extremely destructive. I've seen it. And that's the unfortunate thing. So hopefully everybody's going to be able to abide by this. So again, no contact with victim, residents, or any family member of the victim or anyone that resides in their home, and no third-party contact. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is going to assess $443 in fines and fees. You can pay that at an amount of $50 a month to probation, not here, but to probation. I need to order your DNA. You need to go to the sheriff's department and provide that. This may be a case where you can have it expunged from the CODIS system, but your DNA is already in the system, but that's your call. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, but you could sit up to 6 months in jail and a warrant will be issued. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Gramstrup?
No, Your Honor.
All right. When you're done here, you must go to the jail, provide your DNA or see if they need that, and then go report immediately to probation and then get probation all set up. Is your address still on County Road Z?
Yes,
Telephone ends in 3506.
yes.
All right. Thank you. Then we are adjourned.
Your Honor, I got one thing I do want to say now.
We're back on the record.
So these violations are a year old, almost. And up until these violations came into play, there was calls, phone calls, accusations, lies, up until these violations were filed. But once the violations were filed, it's been crickets for a year because the so-called victim finally got what she's been setting up all this time. And I mean, this is a misdemeanor. I feel like I'm 40 years ago on trial for a murder. This is crazy, man.
I had to say a couple things. One, you said so-called victim. She's a victim. Second is I did take that into account. There have been no violations since this case was filed. And this case was filed in October of 2024. I did take that into account. If there were violations past that date from the filing date, you'd be in jail right now.
Exactly.
So there wasn't. And so that's why I'm hopeful that there's not going to be violations. You're going to build your life. You're going to be able to move out and then have peace.
I know I got one more reason why there won't be any violations, because the parsonage that she lives in, she's being evicted because of
Well,
all the
that's not going
craziness.
on the record.
So amen to that.
All right. That's,
Amen.
please strike that from the record.